Now, ladies and gentlemen, let's get something out here and let's get a better understanding of what we're talking about. Now, I've had to reboot my computer because I wasn't able to bring people on. Ladies and gentlemen, I want you to stop and think. This is part of being a PAG instead of the patriot people. Those people who wants to be the sovereigns, or those people who want to have different identities. The issue here in the IRS is there's two different issues here. There's two different avenues of going after this. Under Title 18 United States Code, Section 8, it gives you a list of items, including Federal Reserve notes, United States notes, that is a pure obligation of the United States government. Not yours, not mine. It is their obligation. Title 12, Banking Laws, Section 411. Again, it goes along with the Federal Reserve Act of 1913, Section 16. Federal Reserve notes is an obligation of the United States. It is not Carl's or Harold's or Harvey's or mine or 64, guest 64, guest 9, guest 88, guest 89. It is not your obligation. But yet we're on here making arguments about the living and the dead. It has nothing to do with living and dead. It has everything to do with is that under the bankruptcy of 1933 and under the Federal Reserve Act of 1913, they stripped you of any type of money. They stripped you of being able to pay for anything. It isn't about, this is all about the dead people. It has nothing to do with the dead people. We are talking IRS here. We are talking under the IRS regulation that you are being taxed on a Federal Reserve note. You're not being taxed on silver. You're not being taxed on gold. You're not being taxed on oil. You're not being taxed on lumber. You're not being taxed on your grass out in your front yard. They are coming after you under a Federal Reserve note issue for payment. The argument here is under IRS Code 6331 Part A, which is what keeps being left out, is that those who are obligated to pay holds a public office either in D.C. or in the government that is working for us. They are the ones who are obligated. The problem of it is, again, these people are being paid with Federal Reserve note. The issue is that Federal Reserve note is not money. It is a mere promise to pay you someday. Has nothing to do about the birth certificate. Has nothing to do with birth certificate whatsoever. Has to do with, now we got the government trying to peep in on this thing to mute this thing out. It has nothing to do with birth certificate at this point. Not in this IRS case. You're missing the point. This is part of the patriot problem here. This is part of the sovereign problem here. You are running a tunnel vision on a birth certificate or a dead man or a dead body. issue here, and this is why you are getting your butts handed to you in these court cases. Dave Bussey and I, in 2010, roughly, I took on the IRS. I took them on for, well, maybe it was 2009. 2009, yeah, 210 to 212. I took them on for 2 years. I did not argue that I was dead. I did not argue that I got a birth certificate. I went back and argued the fact that that Federal Reserve note, under your own statutes, under your own regulations, under your own written words, Federal Reserve note is not money, but a promise to pay. The other issue is, under the bankruptcy, you strip me of any type of money. Under the Trading with the Enemy Act, all property was turned over to you, to the government, for one purpose: for them to sit down to borrow off of you for a period of 2 years for a war that has never ended. This is about the fact of their verbiage. It is about their job description. It is about that IRS field manual that we got our hands on. That sits here and says, not to let this out, if taxes are volunteer. This goes back to that 1953 congressional record of Ways and Means Committee pulling IRS in. And it was stated in the congressional records that they can only tax you on, IRS can only tax you on alcohol, which is liquor at that time, and not personal income. Congressional records flat out say this. They can only tax you on liquor. The word person, I want to give you the definition of the word person. I want you to look under Title V, under 552A. I argued this in my D.C. case. I am not a person. A person under Title V, under 552A, is a U.S. citizen or an alien applying for permanent residency. A U.S. citizen is a federal citizen as defined in Title 26 under 6331 and under Title 26, 7343. You are missing the arguments. You are missing the points of what is being discussed here and what is being done in a lot of these cases. And I don't care what you're saying on 67. Well, one says Treasury for the United States. The bottom line, that Federal Reserve note, it has 3 words on it, 4 words across the top. United States, or it says Federal Reserve note. And I don't care if you want to go to the left side. I don't care if you want to go to the right side. Look at what the paper says at the top. Federal Reserve note. Go back and read Title 18, Section 8. It doesn't say that if you have a Federal Reserve note, if you go to the left side of the Federal Reserve note, then this is your responsibility. If you go to the right side of that Federal Reserve note, then this is an obligation of the United States. It doesn't say that. If you will look at that Federal Reserve note, it is pertaining to the whole note. The left side is discharge. It isn't money. The right side is still an obligation of the United States. But if the left side is a discharge, who are you going to? Are you going to me? Are you going to Carl? Are you going to Harvey? Are you going to any of these people sitting on here? Or are you going back to the government on that left side, and you're asking the government, which is their obligation, to discharge this? This is the point that you people are missing. This is what is being missing. I don't care what lawfulmoneytrust.com sits here and says. This is more propaganda. The issue is that a Federal Reserve note has no value to you and I. It is an obligation as a debt note to the government. And if you would get in and read the congressional records from 1933 and 1932 from Congressman McFadden sits here and says that that Federal Reserve note is a mere promise to pay you someday. And it doesn't sit here and say, if you have that Federal Reserve note and if you go to the left side, then this is your obligation. If you go to the right side, this is the government obligation. That Federal Reserve note is not money. It is a mere promise to pay you someday. And I don't care if you're on the left. I don't care if you're on the right. It is an obligation of the United States. It is an obligation of that Federal Reserve agent. It is the obligation of that bank. Your name is not written in the United States Code where it says you are obligated under this Federal Reserve note. Whether it's the left side, whether it's the right side. It sits here and says both sides, that whole piece of paper is an obligation of the United States. That's the arguments that we need to be walking in here with. The other issue is, it's like Carl ran into when the moment he filed paperwork into this Harold's case, they pulled an IRS judge out of D.C. What did you say, Rod? What did you say? I said Carl pulled an IRS judge out of D.C. They flew one in. This falls under Title 26, under the appendix, under Rule 10. They have to bring in an IRS judge. Majority of you people are not aware. And when you go into an IRS court, you're not facing an IRS judge. Because when the moment Carl faced this judge, that clerk of court refused to accept paperwork because they could not accept paperwork on an IRS case because it was out of their jurisdiction because they brought a judge in from D.C. Ladies and gentlemen, this is the issue. This is the issue. And if you get into the Trading with the Enemy Act and you go back and really understand this, then under Public Law 148 Stat 1, you and I were listed as enemies of the state. And under the Trading with the Enemy Act, under Section 17, it shows that you and I have an alien property custodian. They are supposed to discharge all of our debts. They are supposed to handle our financial affairs, not you and I. These are things that you're missing. These are things that you're lacking understanding and knowledge on and arguments on. Again, you're wanting to sit here and say, well, we got a public side and we got a private side. It is still one piece of paper. You're not getting two separate, different types of notes. It is one separate piece of paper that says Federal Reserve Note across the top. Again, on the private side, you're supposed to be able to go to the treasurer, which is who? The government. And you're supposed to be able to discharge your debt through that government. If you want to stay on the public side, you go to the treasurer, which is who? The government. It is the same office building. Two different people, but the same building. The issue in the arguments are, it doesn't matter whether it's public or private. It's still a Federal Reserve note, and it still is an obligation of the United States. They cannot tax you because congressional records go back and show that they can only tax you on liquor. 1953. That hasn't changed. Title 26, under Section A of 6331, it tells you that it is a government obligation. Those who work for Washington, D.C., those who work for the government. It does not have your name. Again, you're missing the point. You want to sit here and argue, and you want to take responsibility for that note. I want to be obligated on the private side. I want to be obligated on the private side. I want to be obligated. You ain't no way to be obligated on the public side because it's the Federal Reserve note. You're still going to the government to either discharge it or make them obligated. Either way, it's still their obligation. These are the arguments that we're walking in here with. This is the argument I walked into D.C. with on Dave Bussey's case. And what did they do? The court sit here and called it a draw. They sit here and said, we're not going here with you. They terminated the case. They called it a draw because they couldn't beat me. That's the same thing with the D.C. case that I am working with right now. We walked in with their language. We walked in with their terminology of their definition of the word firearm. We walked in with their terminology of their definition of the word person. And we sit back and show by congressional record and under congressional intent that these words cannot, do not, will not ever apply to you and I. We went back and showed that there are statutes, and this is the other issue here, is that USC code, that includes Title 26, in 1925 was never passed into law. It was prima facie. And in 1935, under the Federal Registry and under the Industrial Recovery Act, Congress created an administrative commission and allowed the president at that time and today to go into the statutes at large and codify all the statutes at large for administrative use only. Again, this goes back in and this blows the argument on your side of the fence. But the law says this. You're right, the law does say this. But in 1935, the USC codes and any addition to these United States code under that federal registry and under the the Industrial Recovery Act of 1935, it has made all USC codes and obligation and administrative procedures to hold them accountable. Again, your name is not written in the USC codes. You are trying to take on an obligation. You are volunteering to be liable because you want to be on that private side of the Treasury whenever the laws in 1935 clearly goes back and shows that the USC codes are for administrative use only to hold them accountable. Unless you are a public official, this stuff don't apply. '64, you're not listening to what I said here and said. I told you. The statutes at large is the real law. It is the intent. The United States Code in 1925 under HB 10,000 was never passed by both houses. See, you're not listening. You're not grasping what's being said. You have a preconceived notion of what you think is being said, and you're not hearing what's being said. The statutes at large is the intent. The USC codes is administrative. They were never passed in 1925 under HB 10,000. 1935, the Federal Register and the Industrial Recovery Act of 1935 turned the USC codes into administrative. This was my argument in D.C., and you know what? They could not rebut it. Because I had the statutes at large, and I walked in, I handed it to Judge Kessler, and I went back and said, here, 1925, you never passed the United States Code into law. 1935, it clearly states in here that the USC codes, when they were codified from the statutes at large into the United States Code, they were strictly administrative. They only applied to you and your kind. Has nothing to do with me and mine. This, people, are what you are missing out on. Your arguments that you're making are not proper arguments. You are trying to make excuses. You are trying to qualify yourself to be liable for all this stuff, when the reality of it is their own statutes clearly show that everything written in the United States Code is strictly for corporations, administration, and foreign. Ladies and gentlemen, this is part of what I've learned through being a PAG. My line of thinking has been separated from the most ways of being taught out here. Because number one, I was never taught patriot stuff. And that's what it was called back in the 80s, 90s, 2000, patriot stuff. The gentleman that taught me took me into a law library. He taught me to read their statutes. He taught me to understand their language. He taught me to understand their job description. He taught me to understand their rules, not only the rules of court, but their statutory rules. I didn't have to defrag and unlearn because I was never taught except for what I am teaching and how I am teaching. Well, I'm not confusing the private side. We're not confusing that at all. But you can't use that private side to take liability for Federal Reserve notes and hold yourself accountable to have to pay for Federal Reserve notes for taxes under IRS cases. This is where the mix-up's coming in. All I have to do is see what you're writing on the board. I don't have to know who you are. All I have to see is what you're writing on the board. And what you're writing on the board shows me that you're trying to sit down and claim the private side and claim responsibility for Federal Reserve notes. Ladies and gentlemen, there's other ways of teaching out here. Claiming responsibility for Federal Reserve note is not our responsibility. It's not our obligation. Whether it's private or whether it's public on that Federal Reserve note. That Federal Reserve note flat out says in congressional records and federal statutes, it is an obligation of the United States and has no ties to the people. I didn't lose my 2010 IRS case. I didn't lose it. They called a draw because they couldn't beat me. They wasn't willing to allow them to come back in and say, okay, Mr. Clash, you're right. You beat us. That's the same thing with the D.C. case. All we're sitting here saying is this IRS case that Carl is involved in. There's several ways of arguing this. Here's your written statutes in your books. It sits here and says you're trying to charge me taxes on a U.S. Reserve note, Federal Reserve note. You're trying to charge me taxes, and right here it says in your own book, it's an obligation of the United States. How am I liable? How am I responsible when it says here, 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 and here, you're responsible for it, not me. Now, you want to talk bankruptcy of 1933, where you sit down and you stole my credit line, where you put an alien property custodian in charge to take care of my business? Why are you dragging me into court when you should be dragging in the alien property custodian for not doing his job? Why are you dragging me in when you should be dragging in one of your own agents? Matter of fact, you should be dragging in the treasurer, the comptroller of currency. You should be dragging in the FDIC, because the FDIC under that Federal Reserve Act of 1933, whenever they did that state of emergency, then they created the Federal Reserve Act, and they created the FDIC. They made them the receiver in the bankruptcy. We're not commingling, because if you go back in and understand the statutes is a trust. You are pointing out to them their job duty. You are pointing out to them their obligation to you. As you are the creator, the grantor, the beneficiary, whatever you want to call yourself, these people are the trustees. These people are the property custodian, alien property custodian under the Trading with the Enemy Act. These people have the obligation to discharge your debt. They're the ones who set this stuff up. It is their trusteeship that's in violation here. And when you're walking into an IRS case, the obligation is, excuse me, are we not operating under Trading with the Enemy Act? Yes, we are. Are we not operating under the bankruptcy of 1933? Yes, we are. Then why has the alien property custodian, why has he, and why is he not in this courtroom explaining why he did not take care of the finances? Why are you dragging me in here, knowing that the Federal Reserve note is not money? Because I'm going to tell you people right now, I ran into this up here in Raleigh. I also ran it into federal court in D.C. I had the tax department in administrative court. And of course, the Attorney General went off. Well, Mr. Class brought something in about the 1913 Federal Reserve Act, and he brought something in about the bankruptcy, and it is frivolous, it's unintelligible, it is, uncomprehendable, and on and on and on. He had all these beautiful words. I objected. I said, when he gets done talking, I'm going to rebut this man. When he got done talking, I pulled out two $5 $1 bills. I looked at him and I said, I want you to answer me a question. Seeing how you don't know the first thing about Federal Reserve Act, you don't know anything about the bankruptcy, maybe you could tell me these two pieces of paper that I have in my hand here, would you please tell me on the record what these things are? And the judge told him to keep his mouth shut. I looked at the judge. Will you tell me what these are? He dropped his head and shook his head no. My next issue was, if you cannot tell me what these pieces of paper are, and you will not put it on the record what they are, how in the hell am I supposed to pay taxes on something we can't discuss in this courtroom? Right there is your argument, ladies and gentlemen. If you go back and read that Title 12 and 411, that falls right back under the reserve agent. This is the arguments in the IRS cases, ladies and gentlemen. If they can't tell you what you're holding in your hand, then they can't charge you taxes on something they cannot discuss in the courtroom. Whether it's private, whether it's public. If they can't tell you what that sheet of paper is, then they can't charge you taxes on something they cannot identify. Again, this goes back to the alien property custodian. He's obligated to handle all this issue for you. This is a trusted position. This is a public office. Their own statutes. That's what I'm sitting here trying to get across to you, ladies and gentlemen. USC codes is their administrative procedure. It's their rules and their guidelines and their duties to you and I. I have never, ever used or claimed the USC code to belong to me. And any of my paperwork, if you go back and read it, you go back and understand it, we are coming back in and showing them these are your verbiage, these are your words, this is your language, this is your obligation, this is your duty, this is how you're supposed to operate. I didn't say one thing about raw class. I didn't say one thing about Rod Class having an obligation here. I'm sitting here saying it all falls back under, these are their guidelines. These are their procedures. This is their job duty. And when they don't do their job right, they breach the trust of that position. The choice is yours. I am not here to twist your arm. I am not here to take a sledgehammer to your head. I'm not here to break your kneecaps. I am here showing you, if you go back and read and learn to read the United States Code, and you go back and read the congressional intent in 1925 and 1935, you're going to get a whole different perspective of arguing. You're going to get a whole different outlook of saying, shit, these are their rules, these are their obligations. And this is how we used it. In Dave Bussey's case, this is how I used it in my DC case. This is how I used it in the administrative cases that I've dealt with here in North Carolina. This is why they're coming back and saying the lights are on, but nobody's home. That's why they're coming back and saying these people are private individuals. They don't work for the state. They're not part of the state. They're purely private individuals. This is why. Because when we start coming back in and hammering them under their own language, they could never admit. Because the moment they do, they now have admitted to the fraud that's been perpetrated on you and I. And the moment they do that, they hung themselves. The problem is, the moment they sit back and made the issue, is if they don't work for us, they're not part of us, they've already hung themselves. Because they've already now proven that they're under the corporation side, and they've already proven that they're under the international side. Think about what's going on here, ladies and gentlemen. Think about what's going on here. Those of you that are interested to get into the webinar, you were given email addresses to Steve and to Sue. This is what and how we're going to teach. If you don't agree with this, then stay out of it. My job as a prosecutor, my job as a PAG is to go back and hold these people accountable to their own statutory regulations of how it is written. Because you got to remember something here. You go back and read the statutes at large, it's written one way. You go back and read the United States Code, that United States Code was published through Westlaw. And the moment they published it through Westlaw, it's no longer law, but color. It's concept, it's theory. Because when they start changing the verbiage, and a good example is go back and read the Federal Reserve Act under Section 16 and read Title 12, 411. You're going to find out the verbiage isn't the same. They took away the gold. They took away several words, and the moment they changed their wordings out of the statutes at large, which is the intent of Congress, and they turned it into a USC code, they have now operated on the theories of concept. They have now changed the originality of the law of how it was intended by Congress. This is what I did with them on the National Firearms Act of 1934. And this 1968 Gun Control Act, and the Firearms Owner Protection Act of 1995. And under Title 26, 5845 under IRS, and Title 27 CFR 479.11 under ATF. I walked in there and showed them what a firearm is congressionally and under tax, whether it's IRS or ATF. I showed them the intent of how and what a firearm is. Now, Title 18, 921, gives you a different terminology, but this is going by Westlaw. But whenever they did the Title 26, USC Code 5845, and Title 27, CFR 479.11, Westlaw had to put the correct terminology in there because it was under the intent to separate the word firearm from that of a rifle and a pistol. They had to. IRS and ATF are not exactly the same. ATF is an agency to itself, and like IRS is an agency to itself. One is taxes, and the other actually deals with alcohol, firearms, and tobacco. You have to register if you sit here and you buy liquor, or you buy alcohol, you buy tobacco, you buy a firearm. You have to register with them. You have to notify them. That's what this gun check is all about. That gun check don't go to IRS. It does not go down to Puerto Rico and says, okay, Mr. Klaus here wants to buy a firearm through the IRS, and this is what we're going to go back. Granted, you do have to pay the $200 tax. But these are two separate agencies. These are two separate agencies. They may work hand in hand, but they're two separate agencies. This is like saying that McDonald's and Burger King is the same thing. McDonald's is a franchise to itself. Burger King is a franchise to itself. Does it sell hamburgers? Yes. Do they sell French fries? Yes. Do they serve breakfast? Yes. But it's two different entities. in here for you to go back and rethink some of your thinking. I'm not here to twist your arm. I am not here to sit down and to force you to think any other way. I'm giving you an opportunity for free thinking, to go back and look at something from a perspective maybe you didn't think of. Go back and look at this from a different point of view. I have been successful on arguing this stuff in the manner that I have argued it. Because if I was not successful, they never would have put me on an ankle bracelet for a year and a half, because they were terrified of me, and it wasn't because I had a pistol and a rifle. They were terrified because I had knowledge and I had understanding. I'm coming in here with something that nobody else has ever walked in here with. I've walked in with their verbiage. I've walked in with their rules and their regulations that laid this thing out. Choice is yours on how you want to make and what choices you want to choose and how you want to look at things. But we know the patriot stuff don't work. Going down the same track don't always work. Because if you keep falling off the bridge, or you keep falling in the same pothole, it's time to change your line of thinking. It's time to change your strategy. We got a couple of people who've been waiting. Let me pull in some guests here. We had Virginia, number 2. Virginia, go ahead.
Hey, Rod, how you doing?
Good.
Good. I just wanted to ask Carl a question. Maybe you can answer it for me. Did he say that he had a judgment from a court for an award of a certain amount of money? Is that what he...
Yeah, he has. And it is, we won it. Is that the court is not cutting it loose. The judge refused to turn the money loose. And this is why we're putting in the mandamus. Carl has put in a number of documents to open up this door, but it's like anything else. If the judge don't want to do it, then you can't force the judge to do something he's not willing to do, and that's what we're running into.
Let me ask you this. There's something I was just researching here. It's called a writ of facias.
Yeah.
I don't know if I'm pronouncing this right, but it's FIERIFACIAS. And what it says it is a writ of execution after judgment obtained in a legal action for debt or damages for the sheriff to levy on goods or goods of the judgment debtor. So would that be different than a mandamus?
All right, the problem you're running into is this. It is a little bit different, but still it goes down into how are you going to force the judge to get off his dead ass to go do this?
Well, I think it goes to the clerk, and the clerk taxes the clerk is the one who notifies the sheriff to go out and collect the property or seize the funds. If he's go to the bank and to seize the funds. So I don't think that it actually goes to the judge. I think it's something that the clerk, once you submit it, has the responsibility of contacting the sheriff and making him do it. Since you already have the order that's saying that he won the case and that he deserves the money.
Okay, now hold on a minute. Let's go back in. The money has already been seized by the government. It's already been seized by the government. Now, you are going to go ask the sheriff to go seize a government bank account to get the funds returned, right?
Either the sheriff or, if it's federal, the federal marshal.
Okay, but still, the problem of it is, in order to get that money released, even through a writ, you have to get what from a judge in order to go get this?
Well, you have the order that already claims that you won the case and that the money is due to you. I'm assuming that's what Carl has. And if you have that, then...
It does, but the problem of it is that was in a civil case. We won our civil action. The federal government picked it up. The federal government is now prosecuting these gentlemen up in Boston. The government has now seized all the bank accounts. So, yeah, even though he has a order to collect, the federal government now has brought the case, and the federal government is now sitting on the accounts and sitting on the banks.
Oh, boy. Yeah, that's a tough one there.
Well, see, this is what you know. You got a good thing here, but you have to understand is the fact that just because we won it civilly, and this is why the federal government got into it, because we won it civilly. He won it. And the federal government said, oh, my God, this guy has got this. We better jump in. We better prosecute these guys because we sure don't want this money slipping through our fingers.
Okay.
So now you're going to have to go back to the same federal judge that Carl is going to put this into him and have him overturn his own decision by having himself arrested for not releasing the money. There's a lot more to this than you realize. But no, your question was good, and it was what we're dealing with, but you're not seeing the whole picture here of what we're involved in.
Right. Okay. Well, let me tell you this. The last 2 weeks ago, in my suit against the city of Richmond, I had the opportunity to speak before 3 Virginia Supreme Court justices, because the circuit court here tried to dismiss my declaratory judgment. So I appealed it to the Supreme Court. So I had to go speak before 3 justices, basically giving them reasons why they should accept my appeal. I did a good job at it, so I'm just waiting to hear back from them what they're going to do as far as accepting my, they call it written statements of facts and the assignment of errors. So if they accept that, then I should get some type of judgment as to, what's going to go happen with my case here. But it was a great experience, man. Great experience. But
yeah, it is. But again, we're going to teach how to go in and file the informer pauperis in these court cases so they don't cost us anything, because we're going to go back under the bankruptcy of 33 and under the Federal Reserve Act, and we're going to go back and claim informer pauperis. Because this is what I did in D.C., and this is why the judge allowed me to file for my appeal under informer pauperis, because I went back and proved there's no money.
Right. Well, I did mine under declaratory judgment. That's how I brought my suit in. So that only cost me $150 for the appeal to the Supreme Court. So, I mean, it wasn't much because I think it's because I didn't actually do a lawsuit. I just went through a declaratory judgment.
Yeah.
So, but...
Well, again, even if you fall back underneath this, the issue is, and where you people are making your mistakes, whenever I was asked in D.C., Mr. Klaus, do you own your home? No, sir, I most certainly do not. The county owns it. Do you own your automobile? No, sir, I most certainly do not. The state owns it. Do you pay electric bills? No, sir, I do not, because I have no means of paying anything because we don't have any money. Now, why did I tell them the state owns my house? Or the county owns my house?
Because it's in your all capitals or in the all capitals name registered to the state.
No, it's not, because it is registered to the county.
Yeah, to the county.
Rather, it doesn't matter how you spell your name, because I don't put my name all capital when I turn this over to them. The point being is, under the War Powers Act, under the Banking Act, all property belongs to the system, belongs to the government. So how can I claim that I own a house when it belongs to them?
Okay.
Same thing with the automobile. You don't own your automobile, because if you did, you would have the manufacturer statement of origin instead of the title.
That's correct.
So the state owns your automobile. So do you own your home? No, sir. The county owns it because it's registered to the county. You own your automobile? No, sir. It's registered to the state. Do you pay any electric bills? I have no way of paying them. And that's how I walk it through for my informer paupers.
Yeah, it's basically a usufruct.
Yes.
Yeah.
The moment you sit back and you claim, well, yeah, I'm making payments on my house. I'm making payments on my car. You just admitted that you own property, and if you own property, how can you be informer pauperous? The moment you sit down, yeah, Your Honor, I sit here and I pay out $200 a month for electric, and I pay out $139 for insurance, and I pay out. How can you be informer paupers if you're paying all this stuff?
Right.
See, this is the simplicity of what we're trying to get people to understand.
But what about the other side of that sword, where if you're trying to sue them and you're claiming basically there's no money, well, what do you want us to give you? Credit or?
Well, Your Honor, I tell you what, I will accept Federal Reserve notes. I will accept stamps from the post office. I will take blank money orders from the post office. That's what I put in my paperwork for my mandamus. And the reason why is because whenever I had to pay my $350 fine, I used postal money orders, and I have used $150 in Federal Reserve notes, and they accepted the Federal Reserve notes. So I will accept them back, or I will accept postal money orders.
Okay.
Or I will accept stamps. If you want to give me $6 million in stamps, I'll be more than glad to take $6 million in stamps, because stamps will never lose their value. As long as you don't take them off the piece of paper and put them on an envelope. You can always take them stamps back to the post office and sell it back to them.
Right.
All we're doing is giving you a different line of thinking here, another way of looking at things.
Understood. Well, I'll let somebody else come on, and I'll keep you posted on how my case turns out. What they decide. Okay, man. Talk to you later, Rob.
Yeah, bye-bye.
All right.
Central Georgia, go ahead.
Hey, Rod.
Hey.
Okay. I found it interesting, the topic that you're discussing tonight, as I got some issues going on, and basically a friend of mine here is kind of helping me out. And I was informed today he did a open records request on an open case I got for filing Form 56s against the DA and 2 judges. And I made the mistake of signing somewhere near, I didn't sign by, but somewhere near where the signature line was for the fiduciary. So basically, county is charging me with identity theft and forgery. And what I was told, the shocking news I was told, is that there's also now a federal case because it was IRS forms. So I'm thinking, or I'm wondering, what can I do? And I understand everything that you said. There's no money. They had a fiduciary duty from the beginning to pay my bills, to take care of this, to do that, and so forth and so on. What can I do to head this off? Would this mandamus help, or what should I do? Because at this point in time, nothing federal has been filed. All I've been was arrested for the state charges.
Okay, let's break this thing down. This goes back into the administrative procedure. Are you not dealing with an administrative agency?
Yes.
All right. Who was damaged or injured in your case?
Nobody. Even
no,
though.
No. Let's work this thing.
Yes, sir.
Who was damaged in your case?
Nobody.
Okay. Now, you are being charged for an IRS issue, which we just discussed here tonight, so there's no money. So what you do is you bring an administrative claim against them and address these issues of what we talked about here tonight on the fact that, number one, there's no injured party. Number two, here's your statute that says the obligation is on your side of the fence. How are you approaching me? And under the Trading with the Enemy Act, who is my alien property custodian, and why are they not doing their job?
Right.
You got plenty of avenues here, but where people make their mistake is, like I sit here and said, you want to claim that Federal Reserve note on one aspect of what you're doing because you're making a comment. This is what I just explained on this informal papyrus. When the federal court came to me and they sit back and said, do you own your home? No, I don't own nothing. It belongs to the county. Do you own an automobile? No, it belongs to the state. This all falls under the bankruptcy of 1933.
Right. Well, if that's the case, then, because we're also dealing with the issue on property taxes.
Exactly.
So that's one of the things I sent. I said, send a true bill, and I asked them, what am I supposed to pay you with? And they never replied. They never said anything, but yet they sent a notice telling that they're selling our property.
That's why you have to go after them administratively. You have to go back in and notify, according to the administrative procedures, you have to notify the first party that would come in contact with you, which is the county or the city. So if you deal with the city, you contact the mayor, city council, the city law director, bring a claim, go to the governor and the attorney general. If you deal with the county coming after you, you deal with the county commissioners, you notify the sheriff, you notify the county prosecutor, you notify the governor and the attorney general, but you also go back and notify the tax agencies. You notify them administratively. You want an administrative hearing. You want to address this. Now, the moment you start bringing this stuff up, they're going to do one or two things. Either they're going to sit back They're going to invite you in for a conversation, or they're going to sit back and they're going to throw these agents under the bus. Now you've got them in a tort claim under a Title 42 suit because they're going to claim they don't work here. Don't let them drag you in. This is what I keep telling people. If in my past experience, when I got stopped in Dallas for my ticket, I got stopped at like 3:15. I got home. I had paperwork started that night. That next morning, I had it filed into the court. Less than 24 hours later, I had paperwork filed. Not only into that court, but into the administrative court. Most of you people, and I'm not being nasty here, you will wait till you got to deal with a court case before you file. You file that administrative. The moment they stopped you, you filed an administrative claim against them for abuse, misuse of power.
Well, here, I got an extra monkey wrench thrown in here. Okay, I'm currently out on bail for these other charges, and stipulation of the bail. These people, they don't like me. I remember last year when you originally started with this gun case. You know, you were saying how the sheriff was sitting at the top of your road. These people don't like me. They arrested me. I just finished doing not 6 months. I was sentenced to 6 months. I did 4 months for seatbelt violation and a couple other BS charges. In the process of me being in jail trying to get out on a supersedious bond, my wife put paperwork up. That's how they found this IRS form against the DA. So I'm out on bond, and one of the things that I'm stipulated, I can't file anything into any court against any government employee. So how do I get around it?
Well, this is part of it, but you need to go back in and object to that and make this issue that if I can't file against you, then you can't bring a claim against me. Because if I'm not allowed to defend myself, then you can't charge me.
Okay. Then the other part is this. The guy hasn't got the paperwork yet, but they're going to send it to him. And I have somebody, like I said, working for me or working with me to help me out. So once we get the paperwork, hopefully Wednesday, we'll see. I don't know if the federal paperwork will be in there, but all I know right now, this is just hearsay. I have been arrested federally. I haven't received anything from the IRS. I haven't received anything from U.S. Marshals, anything to that nature. So how do I deal with this situation?
Same thing. You go back in under Title 26, under the appendix, under Rule 10, you ask for an administrative court. You want an administrative law judge to come down to hear this case. You don't want this jerk that's sitting on the bench who don't know the first thing about tax law that can be intimidated by the IRS agent. You want a tax judge. This is what I was saying with Carl. When Carl entered into this case as a PAG, they flew a special judge in from D.C.
Okay. All right. Well, the other thing is this. I'm interested in the court, the PAG seminar. Unfortunately, 1, I can't leave the state. 2, I have no money.
Well, the thing of it is, this PAG seminar is going to be on the internet.
Okay.
All right. So I'm not real sure how they're going to set this thing up. But it isn't going to be that much because I broke it down here the other night. They gave me a ballpark figure, and I don't know what they're going to charge, but it comes down to roughly a pack of cigarettes a day.
Well, right now, Rod, I just got out of jail. I'm not working. My house is up for tax sale.
Yeah.
I'm hurt.
Yeah. Well, we're not going to do this until next month, so a lot can change within 30 days.
Hopefully. Well, what I'm going to do, I'll submit my name in, but I'll tell them I'm the guy that's, I'm jacked up right now.
Yeah.
And hopefully, if something turns around, I have no problem of giving. It's just that right now I'm stuck. I'm not working.
I understand that, but this is part of what we're trying to do here. Like I said, from what I figured out, it's roughly a pack of cigarettes, and cigarettes, depending what you smoke, is anywhere from $5 to $7 a pack.
Mm-hmm.
So, and a lot of people go to 2-3 packs a day.
Well, I don't smoke, so.
Yeah, but you know what I'm saying is we're trying to break it down to that level.
Yes, sir. Yes, sir. Yes, sir.
Okay. Thank you. Let me go and let me get to the next one because it's getting on after 11. Thank you.
Thank you, Rod.
Yep. And up here at the top. All right, go ahead. Drew?
Hey, Rod.
Hey.
Hey, I had a question. You said that you guys had you won a court thing, and the judge wouldn't award it. Have you ever thought about going to the executive office of the court and filing a claim against that man that calls himself a judge?
Well, we don't want to do that yet because if you do, then you're going to have to restart this case all over again. You know, and he's already been in this thing about 4 or 5 years.
But how? Okay. Say I get in a car accident with somebody and they got automobile insurance, which everyone has to have, and you file a claim against your automobile insurance. It doesn't go to the court until you bring it to the court if they're not going to pay. So when you file a claim against their insurance because they're a quote-unquote private contractor, it has nothing to do with the court system.
Well, it does because what you've done, and I understand where you're going, this is part of what's going to be talked about down here in Charlotte is go after the insurance company. The problem of it is, even if you go after the insurance company, the judge could turn right around and throw monkey wrenches into this. This is part of the problem we're running into. This is why we need more PAGs to come out so we can start suing them administratively. This is going to be part of the seminar training, is that we're going to get so far into this, and you're going to have a case. Now, you've already went after the city. You went after the highway patrol, and the ruling that you got is exactly the ruling you want, is that the city has no control over the highway patrol, and if that's the case, then the city prosecutor can't represent them.
Yeah, and I went after the state, and I received, I haven't sent you all the stuff, but I went after the state. I went after I haven't gone after California Highway Patrol yet, but I went after the state, and it's real interesting in the way they came back. And then I was contacted by someone in the state, and we had a discussion, and what they said was really revealing on what they had to say. They basically said they insure the entity, right? But you have to understand, the man acts as that entity, and the man, if he acts outside that scope, it's like, say you get insurance coverage from a car, and the insurance coverage doesn't insure you if you drive drunk. And if you drive drunk and hit somebody, the insurance doesn't cover you. That's basically what the state came back and told me.
Well, yeah, if you're drunk, I can understand that, but this still comes back into is that the state itself cannot be a plaintiff in that courtroom, and that state highway patrolman is like we're bringing up, is they have to have a complaint, an affidavit, and a warrant from a court before they can pull you over. They're not following their procedure. They are bypassing all this.
Yep.
So the state highway, see, this is part of what we're going to get into in this webinar, is we're going to start breaking some of this down. What laws are being violated by, excuse me, by the police officer out on the road that the Bar Association is covering up? Because the Bar Association is telling the cop, look, even though we have the rules that says there had to be a complaint, there had to be an affidavit, there has to be a warrant issued, but we're going to bypass all this. We're going to skip Rule 3 of Civil Rules Procedure. We're going to skip Rule 3, 4, and 5 of Criminal Rule Procedure. We're going to skip the Fourth Amendment. What we're going to do is we're going to bypass all this. Well, excuse me, these are your rules. These are what your obligations are. So this cop is sitting out on the street, not really giving it any thought, but he is out here stalking you. He's stalking you. Now, the moment he pulls you over, now this comes into a kidnapping charge because he doesn't have the proper paperwork to pull you over with. He doesn't have a complaint, he doesn't have an affidavit, and he doesn't have a warrant. Well, Rod, they got probable cause. Nope. There has to be an injured party because this highway patrolman, this police officer, has a vested interest in the outcome under the Highway Safety Act. Now this comes down to personal interest in pulling you over. The fact that he's got you pulled over now comes into kidnapping because he's got a gun on his hip. It comes down to sexual assault because he is patting you down. He's feeling you. He's now putting handcuffs on you. This now comes into S&M, sexual, because now he's putting handcuffs on you. He's taking you down to the courthouse, and now you have to sign a bond. Now you have to pay ransom. If you break all this stuff down and you really start thinking about this, they are not following anything because the Bar Association is not enforcing this. As PAGs, this is what we're going to start coming back in and suing the system on.
Hey, Rod.
What?
Just real quick, when I was talking to the state after a lengthy conversation, what they told me was they understand where I'm going, and they said my best bet would, and they're not giving me advice or an opinion, would be to go down to the CHP and give the officer's badge and his name and find out if he has his own liability insurance, and if he doesn't, then I would know where to proceed after that.
Okay, what they did is they threw him under the bus. The state doesn't want to claim liability, so you are now going to sue him in his private capacity. Isn't this what we talked about down here at the campsite? On those SF-95s, is that we're setting them up to sue them in their private capacity?
Oh, no, I understand fully exactly what they said.
Well, think about it. If they're sending you down to get his badge number, see if he's got insurance, they're asking you not to sue the state, sue him.
And that's exactly what their letter said, that do not sue the state.
Yeah, so that's what I'm sitting there saying. We're setting them up through these SF-95s by going through the administrative. We are setting them up to sue these people in their private capacity and go after their bond and their insurance. You did good. You did good. Like I said, we're setting them up. Ladies and gentlemen, right here's the proof of what we're sitting here saying. He just got a letter telling him to go, we can't sit down and tell you, but we would suggest go down and do this. This is what this PAG is all about, is going after them in their private capacity, like they come after us. All right, thanks, Drew. We'll talk to you later. All right, ladies and gentlemen. This concludes tonight's show of what we're doing. This is further education on your side. Like I said, I've been working with this gentleman out in California. He came down to one of the workshops that we had, went after State Highway Patrol, and now they are not giving him legal advice, but they are pointing him to the direction to go down and get the badge number and the name and see if he has his own bond that he can go after and sue him because the government doesn't want to get involved in this. Ladies and gentlemen, this is what we are talking about. Drew went back and proved that the man had no jurisdiction in town, that the statutes didn't apply. Think about what we're getting into. And I want to tell you right now, those who want to sign up for the webinar, God bless you. But remember, when you sign up for the webinar and you start running this stuff, you're putting a target on your back. Because now you're ruffling their feathers. Now we are getting back, we're being told to go sue these people in their private capacity. The word private, not public. Private. We're going to sue them in their private side, not public side. The man could lose his job, lose his retirement, and lose everything. Because he listened to the Bar Association and didn't do his job right. Think about what's being said here tonight. I want to thank you for being in here. I'm gotten over pretty much my cold of what we're doing. Well, not really cold, my allergies from coughing. Donations are still needed for what we're doing. Anybody wants to donate, it goes to P.O. Box 435, High Shoals. That's two words, H-I-G-H, Shoals, S-H-O-A-L-S, North Carolina, 28077. I am in the process of putting up a workshop in the backyard. One is for my garage, for my tools and my stuff that I have to have for storage. The other half is going to be for my law books, law library, to help further education and be able to sit down with people privately in the library and talk with them. We're going to be doing some broadcasting from there. I'm thinking about doing a couple commercials. And I'm going to sit down and pass it by you. There's already one up on YouTube of what we did here about 2 years ago. It finally come out. It's a 7-minute clip. But I want to pass something by you people, and I want you to think about what we're talking about here. The ASPCA and the Humane Society, they are using psychological, they are using propaganda for you to donate for these poor animals. And I'm not saying that some of these animals are not being abused, but they're sitting here showing you these real sad puppy dog eyes. How many of you people actually seen your dog sit here and get up and do the Snoopy dance with a big old smile on his face all the time? I got a little Pomeranian. Just sit back and look at him. He looks no different than these dogs for the ASPCA or Humane Society. Got the sad little eyes. Doesn't smile. Doesn't show his teeth. Doesn't grin. But they're using the natural look of an animal to sit down for sympathy. But yet you look at any dog that's well taken care of, they don't look any different. What we're looking at here is this. The Bar Association, members of that Bar Association, is abusing you and I. let's start doing some commercials, and I'm thinking very seriously, because once I get my library set up, about doing some short clips of people hiring different lawyers, and you walk into a lawyer and say, hey, this is an IRS case, what we discussed here, there's no money. And he looks at you and says, this is frivolous, this is unintelligible, this is uncomprehendable. But wait a minute, let me show you what's in your books. We don't use those. We use them to charge you with, but we don't use those for a defense, because we don't want you exposing the truth by using our books against us. Same thing with driver's license. Title 49, United States Code, and Title 49, CFR, sits here and says, you have to be this in order to qualify to get a driver's license. And I don't meet these, well, that's unintelligible, that's frivolous, that's nonsensical, but yet here it is in your book. Well, we don't use those books for a defense. We only use them to convict you with. Think about the type of commercial that could come out of this. Think about what people, if they would start seeing this and start looking at their attorneys and what has been said by their attorneys, how many people would sit here and start ripping that attorney a brand new ass like I did in D.C.? Think about it, ladies and gentlemen. I want you all have a good night. Thank you for being in here. And I'll let Harvey know when we're going to do some more shows. Thank you.